Hello, this is Mario Joyner, your Las Vegas probate specialist, here with another video. I appreciate you tuning back into my channel. Today's topic is types of probates in Nevada. It is important to know if you just lost a loved one and will need to open probate, the information I will share with you today will provide a lot of clarity and direction. Knowing the different types of probate will also assist you with the typical time frame necessary from beginning to end. Nevada probates are governed by the law written in Title 12 of the Nevada Revised Statutes, which contains 26 chapters, and they are chapters 132 to 156. While this video includes information on certain probate procedures, before you initiate any probate matters, you should review these laws and consider consulting with an attorney. Are Nevada courts the right courts to use? To decide if you should go through probate in Nevada, you should ask the following questions. 1. Did the decedent live in Nevada? 2. Did the decedent own property in Nevada at the time of death? Thirdly, did the decedent die in Nevada? If the answer is yes to any of the questions, Nevada probably has jurisdiction, and you can go through the probate process here in Nevada. If the answer is no to all three of the questions just asked, then Nevada likely does not have jurisdiction. It is important to know that Nevada courts only have jurisdiction over real property in Nevada. This means that if the decedent lived or died in Nevada, Nevada courts only have jurisdiction over the property or estate located in Nevada. If there's property in another state, that state's laws determine how the real property in that state will be distributed. An ancillary probate, meaning supplementary or an additional will have to be done to change title of that property located out of state. Types of probate. There's affidavit of entitlement, special administration, set aside, summary administration, general or full administration, and ancillary administration. The affidavit of entitlement. Now this is sometimes referred to as a small estate affidavit or 40-day affidavit. If the total value of assets is $25,000 or less and does not include real estate, you may use an affidavit of entitlement to transfer ownership of the assets to the proper beneficiary. If you are the surviving spouse, this small estate affidavit may be used for assets totaling $100,000 or less. You must wait at least 40 days from the decedent's death to use this method of transferring title. Time is typically less than 6 weeks to do this. Special administration. Now this is used when the value of an estate is unknown. It's also used to gather information on the contents of the estate. Nevada set aside. Now a set aside proceeding requires a petition of the court, but is not a probate administration of the estate. Rather, only one petition and hearing is typically required. An order of the court is received which transfers or set asides the assets to the beneficiaries without further administration. This can be completed in less than a month, but to use this procedure again, the value of the assets must not exceed $100,000. To determine this limit, if real estate is involved, then you get to deduct the mortgage amount. This procedure allows for a very quick and inexpensive distribution of real property, which can be sold in the normal course of action. Now, when an estate net value is less than $100,000, the estate, including real property, can be distributed after filing just one petition with the probate court. All of the steps are then skipped. You can sell the real property after distribution, thus no court approval is required for the sale. Now you can file this process in 30 days after the date. Time frame here is usually 4 to 8 weeks. Summary administration. Now once the value of the assets exceeds $100,000, a probate administration is open if the value of the assets subject to probate is between $100,000 and $300,000, then a summary administration is used. The limit was increased from $200,000 to $300,000 back in 2015. This shortens the time required for the notice of creditors period from 90 days to 60 days. This is used when the net value is between $100,000 to $300,000. Court approval is required for the sale of the real property and can be sold after the executor or the administrator has been appointed. That's about 4 to 6 weeks. The buyer can be outbid at the hearing, and this process usually lasts about 6 to 8 months. General or full administration. This is used when the value is over $300,000 in total value, which means you must publish the full 90-day notice to creditors and provide an extra notice that is not needed for summary administration. Property can be sold after the executor or the administrator is appointed, usually 6 to 10 weeks into the process. Court approval is required for the sale of real property, and the buyer again can be outbid at the hearing. This probate lasts about 8 to 12 months, but perhaps it can be even longer. An ancillary administration. Again, this is when the decedent does not live in Nevada, but leaves real property in Nevada. The property must be administered in Nevada. Another state's probate court does not have jurisdiction over real property in Nevada. If the value of the real estate located in Nevada exceeds $100,000, a Nevada probate is required, which would be either a summary administration or full administration, as explained previously. If the value is less than $100,000, taking into consideration the encumbrances or the mortgage, then the set-aside procedure described previously may be used. Usually the ancillary probate in Nevada is started after the probate administration is commenced in the state where the decedent was a resident at the time of death. If you're not sure which probate procedure applies to your situation, or to avoid probate altogether for your own estate, call now for a free consultation. Now, the time and cost of probate. The cost and duration of probate often depends on the level of probate proceeding, as well as the complexity of the decedent's estate. Attorney fees for probate are generally done on a flat fee basis using percentages set by the statute NRS 150.060, which can range anywhere between 2 to 4% of the estate's total value, not reduced by any debts. Now, although some attorneys prefer to bill by the hour, some also prefer the flat fee because they think it's simpler and it makes it easier for the client to anticipate the cost without worrying about the possibility of unexpected hourly charges. Now, what assets typically bypass probate? Keep in mind that not all probate has to go through property has to go through probate. Now, these are referred to as non-probate assets and pass automatically upon death without any oversight from the probate court, including property owned as joint tenants with rights to survivorship, retirement accounts with a designated beneficiary such as an IRA or 401k, life insurance policies, bank accounts with a pay on death designation. Now, these types of properties pass automatically without the need for any type of probate proceeding. Also, property held in a trust can be transferred without probate as well. Now, is probate necessary? If the decedent had property that didn't automatically transfer upon his or her death, then probate is probably necessary. Also, if the decedent owed debts, probate might help to resolve the creditors. Lastly, if there is a dispute as to who has the right to inherit property, then probate should be open. Otherwise, if the decedent left no property to transfer, then probate might not be necessary. I trust that you found this information helpful and provides some clarification on the probate process. This information will be helpful as you begin your probate journey. Have a wonderful day, and thanks again for watching.